With this, we will move on with the next panel, that is panel number 3. The topic of the panel is Mediation is the New Black. This panel will be moderated by Ms. Naveen Merchant, who is the Senior Partner of Merchant Law Associates, Karachi, and she will be discussing on the development of mediation Pakistan since 2006 and rethinking the strategy going forward. Our first speaker in this panel will be Ms. Nudrat Paracha, who is a partner at Samdani and Qureshi, Islamabad, and she will be discussing on the private and international ADR Center, their roles and their impact. Our next speaker in this panel is Mr. Shahan Karimi, who is a partner at Heather Mota & Co. Karachi, and he will be discussing on the pivotal role of lawyers in advancing mediation. Our next speaker is Mr. Oman Memin, who is a partner at Mohsen Tayyib Ali & Co. Karachi, and he will be discussing the imperatives of an ADR center, their role and their impact. Then we have Ms. Haya Zahid, who is the Chief Executive Officer of Legal Aid Society Karachi, and she will be discussing on building blocks of sustainable mediation ecosystem. I will then request Honorable Mr. Justice Jawad Hassan of the Lahore High Court to join us on stage, who will be examining the existing legislative framework supporting mediation and potential areas for improvement. Our last speaker on this panel is Honorable Justice Muhammad Junaid Ghaffar of the Honorable High Court of Sindh, who will be discussing the appointment of neutrals in Islamabad High Court and Sindh High Court, a progressive path forward.
So, mediation is the new black. That is the topic today. And we have got a very distinguished panel with us. I'll start the intro from my left side, going up to the end. And then we will take a different route by asking questions on each topic rather than going around with questions. And in the end, we would like to hear from Justice Jawad. He has got so much to say, so we'll leave some time for him to exhaust his thoughts. So on my left is Dr. Nudrat Ijaz Paracha, is the first Pakistani lawyer to become a fellow of CIARB and the first woman in Pakistan to serve on an exit annulment committee in Washington. She is a pioneering figure in ADR in Pakistan. And beyond having acted in arbitrations before ICC, exit, SCC, and other prominent arbitrations, she is a JAMS fellow and she's affiliated with the International Center for Appropriate Dispute Resolution and Prevention. Our next panelist is Advocate Shahan Karimi, is a partner at Heather Mota and Company and has over 10 years of experience in handling diverse disputes before courts and tribunals. Mr. Karimi brings extensive expertise in civil, commercial, and constitutional and banking matters. His practice encompasses shareholder disputes, company law, white-collar crime, land disputes, public procurement, intellectual property and family law, etc. Then we have Mr. Omar Memon, is a partner at Mohsen Tayyib Ali and Company and holds a Masters of Law degree from London, United Kingdom. Mr. Memon has been involved in alternative dispute resolution proceedings, including handling arbitration matters before arbitral tribunals in Pakistan and abroad. He has also been part of several mediation proceedings, including court-mediated mediations, and has worked with renowned accredited mediators in Pakistan at ADR Center. Then we have Barrister Haya Iman Zahid, a distinguished barrister at law, leads as CEO of the Legal Aid Society, shaping alternative dispute resolution ADR in Pakistan. With over 15 years of experience, she pioneered initiatives for access to justice and empowers individuals. Under her guidance, Legal Aid Society established Micadar, Pakistan's premier private ADR center recognized by the Sindh High Court and federal government. Haya also works on reforming prison legislation and champions gender and child security initiative. Her vision extends to climate resilience and broader access to justice. Then we have Honorable Justice Junaid Ghaffar, and I'm putting actually Justice Jawad Hassan in the last because there is some reason I'm doing that. So Justice Junaid Ghaffar is a legal luminary, achieved a remarkable first-class second position in the LLB exam at SM Law College in 1990, making the inception of his distinguished career with unwavering dedication. He initially practiced independently before joining Naveen Merchant Associates in 2003. In 2013, Justice Ghaffar established his own practice, leading to his elevation as an additional judge at the Sindh High Court in August 2013. Now we come to our last panelist, Justice Jawad. Actually, he needs no introduction. His reputation precedes him. But I'll just give you a little glimpse of what he is. He has rendered recently such beautiful judgments, and he'll be talking about him, and that is his introduction, actually. So Honorable Mr. Justice Jawad Hassan was born in 28 July 1967 in Lahore, Pakistan, in a family known for their contribution in education and administration in Pakistan. Justice Jawad studied at the Forman Christian College, Lahore, University of Westminster, London, University of Punjab, and Pace University School of Law, New York, LLM in 1996, on the Henry F. Felshen Scholarship, and received training at the Hague University International Law and the National University of Singapore Faculty of Law. And he actually recently, we went to Singapore for the ADR training, mediation training, and he's an accredited mediator also from Singapore Mediation Center in Singapore. So with that, we will start the discussion. But before that, to start the ball rolling, I would like to give a brief picture of what has happened since 2006. And why 2006? Mediation has been there, mediation, arbitration have been there for centuries. We find mention in Quran, we find it in Hadith, and in Pakistan, we have Panchayat and Jirga system. So it's something that is known to everyone. But what has changed the entire scheme of mediation is the structured and systematic way of conducting mediation. And that started in 2006. And from there onward, I think I would like to give a brief account as to what has happened and what will be the takeaway from this panel as to rethinking the strategy going forward. So as far as the systematic and structured way of mediation is concerned, it was introduced in US by two stalwarts, namely Roger Fisher and William Ury in 1981, and they were working on the Harvard Law University program, and they came up with a book called Getting to Yes. And that has become a Bible of mediation in many ways. So in 2006, International Finance Corporation of the World Bank Group launched the commercial mediation program for Middle East and North Africa, including Pakistan. Since I was the head of this program, I started off with Pakistan as my first project, followed by Egypt, Lebanon, Morocco, Afghanistan, and lastly, Washington, DC. My intent today is to see how much progress we have made since 2006. And I would be I'll be little, expressing myself as a pessimistic because I have not seen much progress. So please forgive me for that. But all the topics of our esteemed speakers today are so well carved that I'm sure at the end of the session we'll be coming to the conclusion as to why do we need to rethink our strategy going forward. Who would disagree that our courts are struggling, literally struggling to find ways to reduce delays in disposal of cases, to provide a better quality of justice, improve citizens' access to justice, better case management system, and save litigants' costs. Today, we are seeking direct foreign investments for our economic growth. Will it be possible for the investors to invest in Pakistan if the legal system, our legal system is not conducive for them to enter Pakistan with their huge investments because they get stuck in litigation processes, right? Well, IFC's project aimed at relieving the private sector from lengthy court proceedings that are stifling the economic growth. So I started the IFC Pakistan project in 2006. We commissioned, but before that, I would like to say a few words on how, when we started off this project in 2006, I had such big and very distinguished champions with me. From Sindh High Court, we had Justice Mushir Alam and Justice Arif Khilji. From Lahore High Court, we had Justice Umar Bandial and Justice Mansoor Ali Shah. And from the Supreme Courts, our focal point was none other than Justice Tasadduq Jilani. After having these champions with us, there was no reason why the mediation should not go forward. But here are some things that I would like to briefly showcase, is that in our diagnostic study before launching the project, or at the start of the launching of the project, was 1.5 million cases were pending in different courts of Pakistan. There was no legal framework to empower judges to refer cases or enforce mediation settlement agreements. And there was only a two-liner mediation clause at that time in CPC by way of 89A. There were no private court-connected or private mediation centers, lack of awareness at all levels. I'm sorry to say, judges, lawyers, litigants. Lawyers felt threatened that their capacity would be undermined by their clients, so they didn't come forward. Litigants did not want to pay extra fees over and above what they have paid to the lawyers. And debtors and frivolous litigators avoided mediation. Well, IFC's program was very comprehensive, but it ended somewhere in 2010. So what changed in 2006? Since 2006, IFC set up a Karachi Center for Dispute Resolution that was known as KCDR initially, then it became NCDR, followed by other mediation centers as private initiatives. One worth mentioning is the work of Legal Aid Society, which has done tremendous work in the field of training numerous lawyers, drafting rules, standard operating procedures, and many other documents, ultimately setting up a MICADR, which is a mediation center. There is another one in Islamabad that we will be talking to, will be addressed by Barrister Nudrat. And then I myself set up IBA Mediation Center, IBA Dispute Resolution Center at IBA University. Then a huge number of mediators have been trained, 600 trained by IFC, more or less similar number have been trained by Legal Aid Society. We amended the CPC to give a proper framework mechanism for the judges to refer cases to mediation, for mediation. Also, lawyers can apply for the mediations. So the framework is known as 89A of Civil Procedure Code. It was a two-liner. It has now been enhanced to give a very comprehensive mechanism. And there is no, actually we have tried it and there are no hitches not to implement it. Under the High Court of Sindh Mediation Center Recognition Program, 2 mediation centers have been registered, that is acknowledged by the High Court. One is MICADR and one is IBA DRF. So ICADRIP is also designated by Islamabad High Court? Islamabad High Court.
And Law Ministry.
Okay, Law Ministry, fine. So the recently established court-connected mediation center under the umbrella of High Court and Justice Adnan Chaudhary is taking care of it. And we have 40 hours mediation trained mediators working at the court-connected mediation center. And during this time, the judges have been trained as not only as mediators, but also as how to refer the cases under the law, 89A, and how to enforce their decisions or mediation settlements. So all this has been done. Where do we stand today? No doubt there is a lot of awareness. Everyone is talking about mediation. It has become a buzzword today, mostly within judiciary and legal fraternity. However, today, the pendency of the cases from 1.5 million, which was in 2006, it has gone up to 2.5 million. So the burden on the judges have increased. Although we have got so many mediators, law has been passed, mediation centers have been established, but why, there is no uptake of mediation? Then there is a disparity of supply of mediators and referral of cases. Then the last one is some mediation centers are still struggling to receive cases, but the number is so slow that it is even shameful to mention here. So with that, I will open up our panel discussion. And first of all, I would like to ask Haya, Zahid. So Haya, Legal Aid Society has been working since 2006 in the space of promoting mediation. What, in your opinion, are the building blocks of a functioning of mediation ecosystem? That I didn't.
No. But the problem context, it was a light-hearted comment. Assalamu alaikum. It is an honor and a privilege. I'm elated to be here on this panel. My compliments to the Sindh High Court, to the judiciary, and to the organizers. Somebody, a formal panelist, said that it's great to see justice here. I say it's great to see justice and power and passion hand in hand over here. So what an honor. Mediation ecosystem की जब हम बात करते हैं, we need to shed light on the fact that the epicenter right now are the High Court and Superior Court judgments, the 13 or 14 that we're seeing coming out. I'm not going to touch upon them. We have the actual experts and the champions on the panel to talk about them. So at the epicenter right now in our ecosystem is this support that we have with judicial precedents, and we have that trained, sensitized approach. You have champions in all of the high courts right now who are accredited mediators. In addition to this, when you start talking about an ecosystem, pehli baat ye hoti hai ki, is it aligned with your culture and your norms? We benefit, alhamdulillah, from the fiqh and Islamic jurisprudence in this context. आगे चल के आते हैं तो legislative framework की अगर हम बात करें, 8-9 साल पहले ये सूरत हाल नहीं थी. We didn't have it. Now we have nuanced differences, but little pieces of legislation in all the provinces, and the Legal Aid Societies helped draft a bill before the Select Committee in Gilgit-Baltistan. So you've got the framework in place, 89A and 89B. We worked with Naveen and the Sindh Judicial Academy back in 2016 when Justice Mansoor Ali Shah Sahab started his pilot in Punjab. He didn't have the benefit of the cover of the ADR Act, but he did it, It would have taken root a lot faster if that cover was there. And then you have in Islamabad something really novel and dynamic. The practice directions of 2023, in one word at the end, kind of almost secretly but not, talk about mediation advocates now. So they introduce a whole other cadre of practitioners. So the building blocks are judicial support precedent. The legislative framework has to be there in the ecosystem, but then you need mediation advocates, really. It's not going to work without them being on board. मैंने KCDR का ज़माना देखा था. A lot of people are familiar with that. There was some real resistance from the bar. I think my colleagues will touch upon that. Some real solid resistance. But, there was a distrust and there were no incentives. Today, we're here to say we can follow that system where a settlement lawyer makes a lot more money than a trial court lawyer does. We're getting there. And the Legal Aid Society has trained 800 lawyers from the Sindh Bar Council as mediation advocates, and we're doing 100 with the Federal Judicial Academy. So this is recognized, it's lucrative, and it works in harmony. And it's a borrowed concept. But the crux is you need more than a good night's sleep. Just because you're a fantastic litigator, you will do better representing your client in mediation proceedings. Agar aapne mediation advocacy ka course kiya hua ho, you'll get to a better outcome. इसके बाद अगर हम आ जाएं तो of course Mr. Shiraz has already spoken about the fact that you need those model clauses to be introduced. So it's mediation, arbitration, then litigation. Regulators have to come down hard on that. But I want to talk about activating district level legal forums. So in Sindh, we have 250 salisin notified under the Small Claims Ordinance. They're trained by the likes of the Naveen merchants of the ecosystem. They're solid. Let's connect them with the offices of the DC, the AC. Let's connect them with the interfaith harmony committees that we have, with the district peace committees that we have, because that's the point where the public is coming when they have a grievance. So let's nip it in the bud over there before it even comes into court. So what I mean to say is, let's get these professionals on the supply side better integrated through effective referral networks at the district level, where the root of the matter really is. Majority of the pendency district courts ke samne hai. And last, at the tail end, the very welcome mushroom growth, I hope very soon, of mediation centers. We're seeing them, we're hearing about them in full force, but we need to start thinking about better regulation, unified data collection, and standards now, because you want the end user to be a flag bearer of a positive process and experience no matter what the outcome of the mediation is. You can't afford bad press if you want this to take root. Thank you.
My another question to you is, as I mentioned in my prologue, that starting from 2006, we have trained so many mediators. I mean, even Legal Aid Society has trained so many mediators. And then we had this training in Islamabad also for the lawyers. There is a huge supply of mediators, but there is no demand for cases. Or in other words, how do we create the demand? And another way of reducing this backlog is judges referring the cases for mediation to private mediators or the mediation centers. Do you think that is something that needs to be looked at?
We have 3 models in operation in Pakistan's ecosystem right now. Model A, which I like to, and off the record, we at work call the SMASH model. It's the SMASH model because it smashed all the myths about ADR and mediation not working. And 36 districts in Punjab, 30,000 or cases referred to those court annex mediation centers, 50% settlement rate. Ye aapka model A tha. This was run by judges who were the mediators in it. Model B is what we have in Islamabad, as you mentioned. It's got the court patronage. It's housed inside the Islamabad High Court, but it refers cases to outside private mediation centers and paneled mediators. उसकी डेटा ये है कि अब छठे महीने में है वो 218 cases आए हैं 5 महीने के अंदर, and the settlement rate is at 35%. The rest are, I believe, pending. So we have to see how that works out. The cons are you don't have the might of the judicial support so much. People aren't taking it perhaps as seriously as they should. Model C, where I believe there's no demand problem, is the model we benefit from at the Legal Aid Society. The volunteer model, the voluntary model. And I think that's a resource that's completely untapped, Naveen. Community organizations, CSOs, NGOs, they've got the pulse of what justice needs in Pakistan are today. Day-to-day justice ki main baat kar sakti hu, and you mobilize them, you network with them, you build referral paths. You have AKRSPN, you have Sarson, you have HANDS. Ye to Sindh mein hai, Pakistan bhar mein hai. You network with them, collaborate with them. The Legal Aid Society has 600 paralegals. We have 64 CANs, community ADR networks, and some district level ADR forums. They bring clients to the centers. And we have an 80% settlement rate, but majority of them are pro bono because dispute aapka 5 lakh se kam ka hai. So that's kind of our philosophy and our model as well. So I don't think demand is an issue if you go into these untapped resources, which is CSOs, NGOs, and these beautiful networks that we have existing.
Okay, that brings me to the issue of lawyers not being convinced in going for mediation. So Shahan, can I ask you to throw some light on that?
Thank you, madam. Good afternoon, honorable judges. Good afternoon, everyone. Just building on what Haya just said,
Yes.
I think the oversupply question, is directly interlinked with the issue which we're facing with the lawyers.
Yeah.
So I think what is crucial is that there is no willingness. So that willingness can only increase if, let's say, lawyers and litigants are educated about the mediation process. So we have a lot of scenarios where we are going to courts and the judges, the judiciary, are motivating the counsels and the litigants to mediate, but the litigants are taken by a surprise. They are not aware of the mediation process. So what lawyers, they need to do is they need to integrate the mediation process into the legal advice they're giving, which is missing. So if you do that at the very initial stage, and I'm not saying that you put mediation as an option in every case you get. You have to identify cases which can be mediated, with examples like you have administration cases, inheritance-related family disputes, then you have shareholders dispute. Justice Jawad Sirwana has just given a judgment on Companies Act, and Justice Yusuf Saeed in Sindh High Court also has given a judgment on a family disputes. Those are cases which can be mediated. Those are cases where it is the responsibility of the lawyers to educate, to advise the client at the very outset that, look, mediation is an option. Even if they don't opt for that, later on, let's say if we are in court and we face a scenario where, there is some inclination of the judge to take it to mediation, then the chances of, convincing the client increases drastically. So that's the fundamental issue. Another issue is the reluctancy. The willingness is not there. You don't see lawyers moving applications in pending cases. You rightly mentioned there is a huge backlog. And I was talking about, fresh cases or you get when clients come in, but you can also take out cases which are pending, which are cases which haven't proceeded for a very long time. You can convince the client. You can move an application. Let's say in Sindh, you mentioned we have 89 capital A. You can perhaps move an application under 89A, go to the court, even if the other side is not willing. You can make an attempt and then leave it to the court with your assistance to convince to the other opposing counsel or the counterparty to go and mediate. So this is, I think, something which us lawyers, I think we should be doing more and more. We need to see more willingness. We need to see more applications being filed in the pending cases as well.
Okay. So, do you think the courts can come out and help here? Because if they ask the parties, if they see the potential of compromise in the case, and if they ask the lawyers to go for mediation, would there be resistance from the lawyers?
I think if lawyers are, aware of what mediation is, I think the resistance will go away. Another problem we are facing is that most of, lawyers, I'm talking about lawyers, not even litigants, they feel that mediation is nothing more than what happens in a pre-trial in a family court. Okay. The involvement of lawyer is not important. You take the parties, make them sit with the mediator, and you expect that if they want to settle, they'll settle, you come out with a settlement. So the role of lawyer is critical, and I will divide it into 3 stages: pre-mediation, during mediation, and post-mediation. Pre-mediation, you have to advise your client that this is an issue which is potentially or can be potentially mediated.
Yeah, but that is, sorry to interrupt you, that is right. But here the problem is lawyers themselves are not convinced to go for mediation. Even if the judges ask them, they resist. So, you are from the legal fraternity and you talk to your friends. And can you tell us, what is their, what is at the back of their mind? Why they don't want to accept
I think
mediation as
something most of the lawyers here would agree with me on is that once you have jurisprudence available on a subject,
yes,
let's say if you have a client coming in and you coming in with a construction dispute, so you tend to cite a judgment and say, look, aapka masla ye judgment mein resolve ho sakta hai, relying on that. So if we have
but
enough...
Then, we have jurisprudence.
We
Like,
do.
We have recent judgment of Justice Jawad Hassan, then we have followed by Justice Yusuf Ali Saeed, and it is now forming jurisprudence in a way. So I'll come to you later. Let me just go to Umar. Umar, your topic is imperative of an ADR center role and impact. Can you throw some light on this?
Good afternoon, everyone. I would like to start off with what you just now said, that there's a lawyer's resistance.
Loud, a bit loud.
And a very famous quote of my senior partner, he's not here, which he advises clients at the very outset always is that a bad settlement is better than a good case.
Yeah.
So that is an approach which I feel lawyers need to start off with, because yes, definitely there's a lot of resistance, and that is why we have such a big backlog today. I personally believe that there is a mushroom growth of mediation centers right now, but as you said, not enough cases are being referred. If those are not being referred, these fancy buildings will not be of any use. We have, and we can learn a lot from other jurisdictions, and I've prepared a very small slides as well, if we can. But these are some of the statistics from the UK. Now, UK annually, approximately valuation of 20 billion pounds of cases go to mediation. The success rate there today is more than 95%. it is not just court mandated mediations, but people are now themselves voluntarily going for mediations. In addition to that, if we talk about Turkey, Turkey, yes, there is jurisprudence because 2012 onwards the law changed. Prior to that, and there was a strong resistance from the bar as well over there. I'm assuming they were not doing enough strikes or what, but the law did change there. And since 2013 to 2017, the amount of mediations tripled. Now, 2018 onwards, until and unless you do not go through the mediation process, your cases will not be admitted in court. So, it is not just the legal framework will have to be moved here. Yes, we have some amendments in the CPC, but they're not enough to change the mindset and to go forward. Similarly, going forward, we have example of China. If you would just see the stats, there were more than 12.4 million cases referred in China for mediation. That amounted to 40% of their cases filed in a year. So these are some examples that, you know. So our ADR centers, yes, we do need those ADR centers, but where is the awareness? The ADR committee constituted by the Supreme Court, of which Justice Adnan Chaudhary is also a member, and I was going through their website, and I came across that Sindh government spent I don't know how many millions spreading awareness through campaign on auto rickshaws. Now we are living in 2023, and after reading that, I tried to focus a lot on auto rickshaws and see if I actually do grasp something from there. But until and unless those mindsets don't change, I don't think we are going any way forward. In a very small example to give, I think probably a Coke Studio song today has 1 million hits on YouTube in a day. So probably we need to focus more on areas where people can actually create awareness, where people would get to know what it is. Abroad, we see the early party evaluation processes are there in field. There are different mechanisms. Today in courts, when we talk about mediation, one of the judges, Justice Sarwana, I believe, is one who is very proactive
Yes.
in these kind of cases. Justice Yusuf Saeed is also now. But yes, it is not just the lawyers, but I think that entire trend will have to change. And we'll have to first of all believe in that system more, that it is going to work and it is going to resolve, because the backlog of cases that we have, I don't think we are working towards it in an efficient way until, and these are the procedures that the world is not adopting to.
Yeah, but do you think even the courts can help inculcate this habit of going for mediation? Like Shahan talked about lawyers' resistance. You talked about awareness in the masses. But what about the courts which are overburdened with the cases? Like huge number of cases are sitting on their heads. Every Monday I see like 100, 200 cases are on their tables. How can they do, even justice to these cases?
Absolutely. I think the backlog that we have, the burden that the judiciary has, it is impossible for anybody to clear that, number one. Number two, as I said, until unless we do not believe in these kind of mechanisms to resolve our disputes, because people have to be made understood that mediation can actually work for them. You must have yourself seen in court at times where the judges say कि ये application पे तो आपने relief ही नहीं मांगा हुआ है क्या. So the client needs to be made to understand that mediation is actually tailor-made. It can be tailor-made for them. It can be very cost-effective. We see a lot of company matters not getting enough time and people being stuck in small shareholder disputes because उनकी बारी ही नहीं आ पाती. शायद when those matters go to mediation, they can be very easily resolved at that stage,
Right.
and can be more productive going forward for everyone.
Yeah, I'll come back if we have time with your other questions. But I would like to ask Nudrat to you that your topic is private international ADR center role and impact. Okay, so what role is being played by ICADERP in redefining the ADR ecosystem of Pakistan? This is something different from what we have been doing here in Sindh. So it would be nice to hear from you. Yeah.
Thank you so much. Assalamu alaikum and Bismillahir Rahmanir Rahim. Thank you so very much to all of you who have taken out the time. I do hear a lot of pessimism from what is being said. But I think the people in the room is the testament that we are looking at a point in history which is going to redefine the ADR space in Pakistan. So I will begin with, first of all, a small clarification. I have been informed about 5 days back, a center has changed its name to ICDAR, which is almost the same name as ICADRIP. They say imitation is the best form of flattery. We will be issuing a formal clarification in this regard. But coming back to the topic, I bring to you an international perspective. I have traveled to many countries. I have looked at how at least 120 jurisdictions have gone about setting up ADR systems. And I am right now ICADRIP. I am the CEO of ICADRIP. And this is the only center of its kind in terms of its international reach and international offerings. So in Islamabad, there are 3 centers. One is, as was mentioned by Naveen, one is Mekaider, one is set up by an advocate, Adil Anwar, Mr. Adil, and then there is the third one that is being, that is our center, ICADRIP. Now, the center was set up as a flagship project, right, to bring to Pakistan the best standards, and you might be amazed to hear that 40 years back, when US started the organization, it was a private organization called JAMS, Judicial Arbitration Mediation Systems. When JAMS was started in the US, it was started by 3 judges. And to begin with, they tell us that they had absolutely no cases. The judges would sit in their room all day long waiting for cases. And right now, JAMS, in the last 40 years, they do about 26,000 arbitrations and mediations a year. So when we created the center, the idea was we bring the best practices from the world, and all the people on the board of advisors are the founders of JAMS in US. And we are privileged to have on our board of advisors Justice Tasadduq Jalani. What we have seen in the past years, there has been an incredible effort to push ADR in the right direction, but what I am seeing from the last 3 years when ICADRIP was incorporated, I do feel we are standing at the tipping point. And at this stage, the like-minded people who are pushing things in the right direction, if they keep at it a bit longer, I do feel that this will be the tipping point in the history of Pakistan. ICADRIP was created with the objective to increase access to justice and to provide a parallel system of institutionalized ADR in Pakistan, that is arbitrations and mediations. In China, for instance, ad hoc arbitrations is not even permitted. In Pakistan, people have lost their trust over many years on the ADR system. For an exit case that I was working on, I had to research the statistics. And you would be stunned to find that high-value cases, ad hoc arbitrations under the 1940 Act, take approximately somewhere between 25 to 40 years from start to finish. In 25 to 40 years, any business would be killed. Amongst others that we have been talking to, the business community has a very acute sense what it means for the money to be trapped into disputes. And for that money to be trapped for 25 to 40 years would kill any business. So what we are doing is we founded this center with on the board of advisors the best people. The patron-in-chief is Judge Charles Brower. He is a giant in the field of investment arbitrations and international law. And we are providing a full range of services. And we are in the process of helping the government with these reforms. So we are providing facilities not only for dispute resolution, but for dispute prevention. We are providing arbitration services, consultancy services. And in addition to that, we are providing training, because ADR, like any other system, would have to be nurtured. It is in its infancy. People would have to create capacity. That is where we are putting in a lot of effort. Now the center has become a certified mediation training provider for International Mediation Institute. So we can provide accredited trainings for mediation. We have again, international collaborations with Pepperdine University, George Washington, American University, Edwards Academy, and the leading institutes in the world to provide these trainings not only to the judges or the lawyers, but to the business community and to the private sector, because all of us will have to work together in order to reduce the burden of the courts and to provide for ourselves an effective mechanism for resolving these disputes. And in US, for instance, about 85% of the disputes now, this was not the case 40 years ago, but in US, 85% of the disputes are resolved through a means of ADR, and only 15% now goes to the court. With all the champion judges and all the people in this room working towards ADR, I see no reason why in another 10, 15 years, the landscape in Pakistan is going to change drastically. The center has also created collaborations with key centers in China. We are finalizing the MOU with organizations like CTAC. We have collaborations with Belt and Road International Mediation Center in Beijing for transparency and promoting the education and the availability of arbitration cases and mediation precedents. We have signed a MOU with Just Mandi, which is a leading platform. So all these efforts are in the direction to help those who are working towards promoting ADR, to bring them together on one platform and providing a more effective dispute resolution for the citizens of Pakistan and for the investors not only in Pakistan, but for investors outside Pakistan. Thank you.
Thank you, Nusrat. Taking opportunity from this occasion, I would also like to acknowledge Justice Jawad Sarwana's efforts, and of course Anwar Kashif, who was here a while ago. We have worked together in promoting mediation, and Justice Jawad Sarwana has been sending a lot of cases also, referring all the lot of cases also. So I would like to acknowledge his efforts from the very beginning of this project. And that brings me to Justice Junaid Ghaffar. And sir, since your topic is appointment of neutrals in the Islamabad High Court and Sindh High Court, a progressive path forward. So my humble question to you is how, in what manner neutrals are being appointed in the Sindh High Court?
Thank you, Naveen. Well, a lot of explanations and things have already been said about the appointment of mediators and neutrals. But to add to this briefly, I would say that the procedure has been prescribed in section 89A of the CPC, and Sindh High Court has adopted this, and in that regard, Mr. Justice Adnan Iqbal Chaudhary, who is heading the ADR committee of the Sindh High Court, has already made efforts to advertise this and to call expression of interest from various people who are into mediation. So firstly, as you all are aware, that the mediation centers can be accredited with the High Court, and already we have 2 mediation centers which have been approved or authorized for this purpose. One is the MICDR, this is Musalia International, being managed by the Legal Aid Society and Mr. Justice retired Arif Hussain Khilji as its managing director. The other one is the IBA Dispute Resolution Forum, established by Mrs. Merchant. Then the requirement of 40 hours training is there for a mediator, and any individual can also approach the High Court pursuant to the advertisement and can be enlisted as a certified mediator, as a mediator to whom cases can be referred. The third is like the district judiciary, out of which many judges have been trained by the Sindh Judicial Academy, and once again through Mrs. Naveen Merchant, who is a certified trainer, so as a master trainer. So there are like 20 or 25 maybe judges from the district judiciary who have already been trained and are working with the Court Annex Mediation Center. So This is like the process over here. In Islamabad, what I have noticed is that they have their own Act of 2017 and their rules have been notified. Over there, perhaps the conditions are somewhat differently notified, I believe. And over there, 7 years standing is required for a lawyer to become a neutral. And then some retired judges, judicial officers, civil servants even can be appointed as neutrals, ulamas, jurists, and experts and professionals. So this is like the requirement and the procedure being adopted for appointment of neutrals in Sindh High Court. Now, secondly, our focus as of today of the judiciary, speaking on behalf of the judiciary as a whole, is that under the aegis of Justice and Law and Justice Commission, a committee has been formulated, and our main focus is on mediation for the reason that we cannot take care of so many cases. So our priority perhaps is to the court annexed mediation, which is like a quick way for taking disputes to mediation. And in that regard, you may appreciate that logistic facilitation is the first and foremost thing which is available for court annexed mediation. Then it gives the litigant a sense of confidence in referral of its matter to the ADR center. And these kind of mediation centers, court annexed mediation centers, are successfully working in Beijing and Kuala Lumpur, as have been visited by Mr. Justice Adnan Iqbal Chaudhry. A judge member or a judge mediator is better equipment to evaluate mediation when the case is put up before him, and is generally and perceived as an expert in law applicable to the dispute. So this is also one of the reasons that we want these court annexed mediation centers to work more. And there is one thinking that perhaps this court annexed mediation center is kind of free service. So it is not as that context, because the cost is there, but the cost is being borne by the court, in fact. So we need to keep this in mind as well. And insofar as the district judiciary is concerned, I would like to inform that as of today, perhaps 48,000 approximately, 48,000 civil cases are pending before us. And out of those, there are 18,000 family cases. So we intend that these cases which can be mediated should be referred for mediation on a priority, and people be convinced to take these cases to the mediation centers. And lastly, there are 2-3 discussions about why mediation has not been that successful as it ought to have been. So my personal opinion, I will share my personal opinion in that regard. There are 2 things which I think are the biggest impediments. One is our mindset. Our mindset has to change, that instead of going for litigation, I have to go for mediation. We have some ego problems. In family matters, we have seen we are revengeful. We want to take the case to the fullest extent. We do not want to settle petty matters in family disputes. So this has to change. And secondly, and the most importantly, is the element of lesser cost on losing your case, no cost on losing your case. In international jurisdictions, you may have noticed that mediation is successful because the losing party pays the entire cost. Over here, we do have costs, but those costs are not documented actually, or we don't award those costs as a natural course. So it should be mandatory that the entire litigation cost and the actual cost which the lawyer has taken, with invoice and without invoice also. So only then you can convince people to go for mediation, and the consequence of that cost may be one of the reasons to persuade. And lastly, for the lawyers, we have seen that there has been reluctance because they are making good money in litigation, so they have to forego something and not being too selfish in these matters and try to convince that this is the case which can be mediated. We won't go for litigation into it. Thank you.
Thank you very much, Justice Junaid. I mean, as far as the lawyers are concerned, I think they should know one thing, that when the case comes to them, they charge fees which is paid upfront to them. And in that fee, they do the efforts for like 10, 20, 30 years. So if the case comes or case is recommended for mediation, they have already taken their fees. So what are they losing? And this is my advice to my fellow lawyers, my brothers and sisters, that we are not losing anything. And another thing Justice Junaid said is that what is the, why we are not changing our mindset. One thing I have experienced in my this efforts to make this process popular is that mediation is too simple. It is too simple, and that is why it's scary. It is too good to be true. But at the same time, it's a magic. It's a simple process, flexible process, but it, at the end, it serves the purpose of resolving disputes. And the best part of it is that it preserves the relationships of both the parties for all times to come. So with that, I'll move to Justice Jawad Hassan. And your Lordship has, his approach to the mediation based on the Churchill judgment recently, which has been passed, and that is Moga Valley judgment, has created a new trend in Pakistan, sir. This judgment has been followed by, of course, Justice Yusuf Ali Saeed and Justice Shahid Karim in huge, fraternity feuds. I would like to ask you, what made you give this first of its kind judgment, whereas, the mediation has become mandatory by the court? So can you please, if you want to use the podium, that's fine.
My name was taken as Jawad Sarwana, Jawadul Hassan, because what I did for mediation, Jawad Sarwana did something, so people start calling me Jawad Sarwana. So my name has now become Jawad Sarwana because he's a leader in mediation. My task today is to wake you up, because it takes you 10 minutes to digest the food and sleep. So I'll take 10 minutes, 5 more minutes to wake you up with a success story of 5 months in 5 minutes. How we developed a concept of mandatory mediation, followed with respect, acknowledged by the West, followed by judges in Pakistan. We have got all the booklets with all the judgments. But what made me do that, the topic is mediation for black. Justice Bashir Alam Saab, when we started this movement 5 months ago, he came to the Pindi bench and said, when I started the mediation concept, वकीलों ने उखाड़ दिए थे stages को. उन्होंने कहा खबरदार हमने शुरू नहीं करने देनी. This is something which they never liked. I was a corporate lawyer. I used to do a lot of cases in London, ICC. I also never liked mediation, but since what made me realize for mediation is the tool. Mediation is something very successful. We have an ecosystem we have developed so far, and I must acknowledge Sindh High Court with CIRB that they have brought the entire ecosystem of Pakistan under one roof today. The ecosystem consists of the superior court judges. The ecosystem consists of the lawyers who have been appearing in all the cases which I refer. The ecosystems have the district judiciary, the vision of the Chief Justice of Sindh High Court, and Justice Adnan was mentioning me today. They included the entire judges because centers can come and go, but if the judges are not there, and the judges are the main player, the critical, interdependent, and symbiotic relationship with the judiciary. If judiciary likes Justice Jawad Sarwana, if judges like us, and judges who, because laws has been there, what I will start is 5 days ago, biggest corporate dispute in India was resolved through mediation. How we resolve corporate disputes in a big family matter, I decided a corporate dispute, and I appointed Justice Jilani last week in a very big family matter. Justice Shahid Karim, a very renowned family matter, appointed Justice Khilji Arif, and Justice, you appointed Khilji Arif, and Justice Shahid Karim appointed Justice Bashir Alam Saab. In a very big matter, he's doing an arbitration mediation in Lahore. What happens to India and why they are successful is the Godrej family, 120 years old, is now safe. The family of Ambani, the family of Tata, the family of even Nulsi Wadia, the grandson of Justice Jinnah, he had the issue solved through a mediation in Mumbai. Lawyers thought what we are thinking now, they thought 10 years ago. The Parsi community sat down and saved a big, huge family concern of cases. What is mediation for Pakistan? The approach is, which I learned while sitting as a judge in London last year with Justice Lady Suker, the Chief Justice of England, and Master of Rolls, just as Jeffrey Walks, they said to me, well, we are going to now resolve 10 years issue of can a court direct a party for mandatory mediation without the consent. Because the Hillsley judgment 2004, England and Wales Court of Appeal, page 142, was saying, no, I paid the tax, I hired the lawyer, and I want a decision by a judge. That was overruled by James Churchill versus County of Wales, 2023, England and Wales Court of Appeal, page 1416, that says court can direct. Same day, a case came to me, and I was hearing a case, Mr. Ahmed Bilal Sufi was the counsel in that case, a big matter came to us. What we thought that, can I do a mediation in Pakistan? There are laws, I know, 89 CPC. There are laws, income tax laws, I know. There are provision in the law, but can I make a first jump? I never realized that my jump, which I jumped first time in 2024 CLD page 1, would have been accepted, followed, relied, and respected by other courts, not in Pakistan also across the border. The jump was very easy. A jump was very easy. I'll explain that to you, that we need to jump unless we know 4 core areas. First core areas was, we need to strengthen the regulator. The concept of regulator. In SECP 2021 CLD page 931, we had to build what SECP is and how it as a regulator can do a regulatory mediation. Because most of the cases coming to us is an issue between, which is against the SECP or a shareholder. Or some State Bank 2023 Lahore, page 382, where we held that State Bank is a regulator. Justice Jalal Samad Usmani is sitting here, who is now the State Bank, when the judgment of the State Bank was declaring State Bank as a regulator. When the regulator acts as a regulator, most of issues will not be coming to court. So once we set up the commercial courts in Punjab, Justice Shah mentioned when we were launching the arbitration law last week, we also mentioned that we need to have the commercial court, because we attended the commercial court conference of the judges, and Punjab had the commercial court, and they were acknowledged by that Pizza Hut judgment 2021 CLD page 639, stating that it's the ease of doing business. Pakistan needs to improve its ranking of business in doing it, and commercial court is a main commercial component for international dispute to be resolved. Then Justice Yusuf Saeed in G.A. Pathan versus Federation of Pakistan, PLD 2023, Sindh, page 781, has then developed the concept of commercial courts in Sindh. So something I want to share with you by pausing for a minute. Pakistan judiciary is united. Pakistan judiciary is together. Pakistan judiciary is there for the issues of dispute resolution. On a Saturday, the entire superior judiciary with the district judiciary is sitting with us. When I was speaking to the launch in IBA last week, I said to the businessmen, the entire business community with IBA was sitting there, that on Friday afternoon, we are not playing golf, we're not on a boat. We are all sitting for 4 hours to learn and resolve the issue of 60% of Pakistan commercial hub. It looks good internationally. That is what Pakistan needs today, because we are sitting and speaking and standing in the city, Karachi. The entire commercial law was built up by the Sindh High Court. I must acknowledge the role of Uzeen case, Okhart case, biggest cases in arbitration where courts were mentioning less intervention in the arbitration, the concept of venue changing to Pakistan, the concept of saving the cost in the international arbitration by Justice Nasrul Mulk, Justice Ajmal Mia Sahab, Nasir Aslam Zahid Sahab, Salim Asriki Sahab, Salim Akhtar Sahab, and only way that the most cited judgment per day by 117 judges of High Court, 4,200 judges of the whole Pakistan, 5 provinces, various districts is Shala Zia Wabda, by against Justice Salim Akhtar, PLD 94, Supreme Court 693. Different things, that judgment has different flavors to it. Their judgment is the first judgment in the world which says that soft law can be made hard law if it's enunciated in the Supreme Court judgment, because what the whole judges, judiciary are hearing, the district judiciary, Pakistan has a very unique constitution. Article 189 clearly states that the judgment of the Supreme Court enunciates a principle of law and decides a question of law, it shall be binding on the courts below. And the judgments which we are giving from the high courts and all with the issue of ADR and mediation, there is subject to Article 189, a high court decides the question of law. And then the district judges who are hearing today, sitting with us, will be what is the way forward? That is what I wanted to say. So issue is what happened to that case. A case came to a corporate dispute. I thought, what can I do? I looked at the preamble of the company law. Preamble gives me an opening which says, whereas it is provided for the effectuous resolution of corporate dispute. Then I touched upon the matter was before me under chapter 9 of 286. But when I examined chapter 8 of the Companies Act, that gives me a straight indirect provision of mediation by the commission. It says commission can mediate a matter. Commission can refer a matter for mediation. I'm not a commission. So what I held in 2004, 24 CLD page 1, if a law empowers a government functionary to get the notification to a high court judge, because I act as a company judge and I act as a merger judge. Merger position is not with us under 284 of the Companies Act. It is the commission which is given through the section of the Ministry of Finance. If you give me the power, I can take the power. The power of the commission can be a power of the court. And the power of the court is to mandate a party for a mandatory mediation. The word used, mandatory mediation, what Churchill said. I'm not going to ask you. What concept was in the mandatory mediation is the concept of ENE, a new concept called early neutral party evaluation. In all corporate disputes in the world, judges, a commercial side, they say, I am referring a matter to ENE, which is you evaluate your case, and if it is successful, go for mediation, and if you failed, then I will go to another term called time-specific, time-bound company law section 6. In one of the judgments I held in Lieutenant General Mahmood Akhtar versus SCCP 2022 CLD page 718, that company law states any company petition filed before the company judge, there is a case management plan and a case management conference, and the parties are directed to file its reply, and the court shall not exceed 120 days in the company petition. This is the commerce of Pakistan. So that is if he fails. So what in that judgment we examined and looked into is that we examined that a court can direct, and court directed, parties sat down. In the 5th meeting, they came and said, we are settled the amount. That judgment came in November, and the story goes on that why did I do it? I had to do it because I saw Justice Iftikhar Chaudhry's judgment of Atak Oil 2007 SCMR page 905 indirectly mentioning mediation in the opta dicta part. Then I found the judgment of Justice Munib Akhtar 2012 Sindh page 388, the case of Asif Shahjani, where my lord mentioned mediation in state decisis. But I never had a judgment on a ratio descendi on mediation. So you have to look into judgments of the courts which were mentioning mediation but not directing mediation. So what we did was, we from the opta dicta, from the state decisis, we came to this point, and luckily then Justice Yusuf Saeed was the first judge to adopt this thing, that approach in a very famous case of Sindh High Court. A suit was pending before his lordship, and then that case was Sajjad Arshad versus Pervez Arshad, suit number 1721 of 2022, where that was referred to a mediation, and Justice Khilji Arif is doing that mediation. Then Justice Shahid Kareem, they gave the mediation by appointing Justice Mashir Alam Saab. Then Justice Masoodi Shah, in the two recent judgments of Sindh High Court, or Supreme Court of Pakistan, in 2024, Supreme Court of Pakistan, page 123, has given the whole concept of what mediation is, how pro-mediation bias is to be approached taken by the Supreme Court, and then he referred his earlier judgment of RYK versus Federation of Pakistan, 2023 SCMR, page 1856, where my lord has mentioned what the ADR show cause is akin to a mediation. So I wanted to share with you, since morning we've been discussing here, that what Pakistan judiciary has done, and I want to end up in saying the conference is on the concept of dispute, and Pakistan looks good. Judges, all judges have done great work in mediation, but we started by Justice Jawad Sarwana Sahab. मुझे भी सारे सरवाना साना ही कह रहे हैं आज, तो मेरा नाम पढ़ भी जाना है, मेरा नाम कभी कोई और लेता है, उल हसन आया, कभी जवाद ख्वाजा साहब, मुझे हमेशा नाम मेरा कभी किसी ने ठीक लिया ही नहीं किसी कॉन्फ्रेंस में. आई नेवर बीन टेकन अ स्ट्रेट नेम बिकॉज ऑल माई नेम्स हैव बीन उल और ख्वाजा और सरवाना. टुडे आई गॉट अ थर्ड फोर्थ नेम टुडे. So anyways, I end up with this saying that Pakistan ecosystem on mediation has been strengthened. This is the efforts of Sindh High Court and all judges sitting with us. Everybody has contributed. Even the Peshawar High Court, Justice Ejaz Sahab is sitting here. He was the first one to give a first judgment on foreign arbitration of SAF power case. And every province has contributed everything to High Court in various ways. Even Adnan Sahab is sitting here, Mashir Alam Sahab, Filji Sahab. Everybody has contributed to a lot in Pakistan. And we must thank the judges sitting with us today who are a future of Pakistan. And judiciary is united. Thank you.
Thank you. Thank you so much for enlightening us, Justice Jawad Hassan. I'm sure I'm taking your Lordship's name correctly. So we have a little time left, and I would just like to present the conclusion from today's discussion, and that is our judiciary has many ideas on reducing burden on the courts, and this is a huge problem. However, rectifying these problems in a long run requires extensive judicial reform program. One alternative that can deliver immediate result is through expediting the process of case referral for mediation. So here, so many are High Court judges who have been accredited by international body in mediation training. At least 5 of them I can name. Justice Arshad Hussain, Justice Jawad Sarwana, Justice Abdur Rahman, Justice Munib Ahmed, and one more name is not coming to my mind, but at least five judges are there. These are the champions. And we now have Justice Yusuf Ali Saeed and Justice Chaudhry Adnan, I don't know why, Chaudhry Adnan. These are the champions, and going forward, I think mediation, referral for mediation should be expedited. And according to the new law, 89A, I'm talking about Sindh Civil Procedure Code, the courts at the first instance, and this is mandatory on the courts, to examine the plaint and see if there is a potential for mediation even before the defendant has come forward, defendant has filed his written statement. Even before that, they can refer the case for mediation. So according to this, they can refer the cases, and lawyers also need to come forward and be generous in accepting court's recommendation for mediation. And I would request again Justice Adnan Chaudhry to see if we can create a similar mechanism for getting the independent mediators registered in the High Court, so that judges should have the list of those mediators, so that our huge supply of mediators can be exhausted.